judicial activism and public interest litigation. Public interest litigation in India, let me just sort of pull out, I'm kind of way behind here, I have not opened this, so, okay.
It's here at about 12:30.
Okay, all right. Public interest litigation in India is, the Supreme Court has always had sort of this very judicial activist role. In its early history, the Supreme Court of India was actually pretty conservative. It protected landed interests, etc. But right after the emergency in India, which was imposed by Indira Gandhi in the late 70s, the Supreme Court actually tried to redeem itself by taking a very different position. And since post-emergency, the Supreme Court has been quite different in terms of its role. It has taken on, and it was because of two Chief Justices that it took on this very, very kind of strong role of providing kind of justice to the disempowered. The political ideology of two justices, P.N. Bhagwati and V.R. Krishna Iyer, actually the first two justices to institutionalize public interest litigation is very, very important. I'll just read you one, P.N. Bhagwati's argument in Bihar Legal Support Society versus Chief Justice of India case. Here's from the ruling. The weaker sections of Indian humanity have been deprived of justice for long years. They have no access to justice on account of their poverty, ignorance, and illiteracy. They're not aware of the rights and benefits, kind of paternalistic, but they're not aware of the rights and benefits conferred upon them by the Constitution and law. On account of their social and economically disadvantaged position, they lack the capacity to assert their rights. They do not have the material resources, etc., etc. And so what they recommend is, they recommend, as I say, tools of PIL, liberalizing locus standi and continuing mandamus. What does that mean? Liberalizing the rules of locus standi permits a third person, a civil society group, including social activists, non-governmental organizations, and other representative bodies inspired by public interest to register a public interest litigation with the Supreme Court, okay, on behalf of a certain group. In addition, the court may self-engage in suo motu action on the basis of a letter, of an article in a newspaper, and other signs that they interpret as writ petitions. Such action by the courts on the basis of epistles or letters is known as epistolary jurisdiction. More recently, since 2006, the courts have also encouraged and entertained e-filing, okay? The liberalization of locus standi has really given social activists access to the judiciary because they can file a writ petition on behalf of others. And so social activists have actually used this space that the judiciary has created to counter certain vested interests in Indian society. Okay, and this has become this very, very influential kind of tool that they have used. What is continuing mandamus? Under the writ of continuing mandamus, courts issue regular directives for evidence collection and for monitoring the compliance of agencies. Courts can also appoint commissioners to investigate non-compliance by the state. And based on the report of the commissioners, can actually seek redress from the state. So this is a very powerful tool that has now been opened up to civil society in India. Evolution of the concept of continuing mandamus as well as liberalization of locus standi have encouraged petitions related to protection of fundamental rights, environmental rights, human rights, including gender justice. We've seen many petitions on labor rights, children rights, food security rights have also come before the court, okay? Here I'm actually just looking at BTGM crops, okay? I'll come back to Habermas. I sort of use Habermas, and I'll be happy to answer. I don't want to I'm kind of short on time, so I don't want to take up much more time here, but Habermas talks about the creation of public spaces, alternative public spaces. And actually, there's a scholar, actually a German scholar, and it's an interesting story which I won't go into right now, who actually used this Habermasian notion to study environmental litigation in Indian social movements, okay, through actually a high court in Calcutta, not the Supreme Court, which is what I'm looking at. And although I find Habermas's notion of creating space for publics useful, I think Nancy Fraser's critique of Habermas is much more useful, because she talks about, she sort of introduces the issue of counter publics, that is, that gendered, racialized, and classed peoples not finding space within the dominant public space, and therefore the need to create counter spaces. And so I kind of, and I'll be happy to go into that if you're interested, okay. So I focus on 3 PILs: the Gene Campaign and Suman Sahai, RFSD and Vandana Shiva, Aruna Rodriguez, Devendra Sharma, and P.V. Satish. So here's Suman Sahai, okay. They had, Gene Campaign is an organization which is based in New Delhi. I spent many, many hours talking to Suman Sahai and many other Gene Campaign people. Gene Campaign people had participated actively in all the meetings and in the food marches that I actually also participated in, that were in New Delhi, from a place in New Delhi then to the Capitol building. They had, Gene Campaign had a conference in 2004 amongst major scientists and other stakeholders, and they had come up with some they had come up with 20 recommendations which they sent to the Department of Biotechnology relating to how to handle GMO crops, okay? The Department of Biotechnology rejected those and said, we already do this, which they don't, right? At that point in January 2004, Suman Sahai and Gene Campaign filed a PIL, a public interest litigation, with the Indian Supreme Court. And this is what they asked for. They asked for the development of a national biotechnology policy, a better regulatory regime, which is more transparent and open, referring back to the Cartagena Protocol. And they said that there should be a moratorium on all crops, on all GM crops, till such a policy is developed, because there is no way of assessing whether these crops will do harm or not, okay? The Supreme Court has passed interim judgments. The case is still ongoing. The Gene Campaign also filed interim applications, and in the interim application they asked for the release by GEAC of allergenicity and toxicity data, which they have not been releasing. And they talked about the contamination of fields in Jharkhand, which is near Bihar, in northern India. And they said that they should actually look into developing greater distances between GM fields and non-GM fields, so that this contamination risk might be lessened. They also asked a regulatory regime to be created, because they said that the regulatory regime, remember I said rules 1989, had not been following the precautionary principle nor the intergenerational principle, okay? The case is still ongoing. Okay, the second, Navdanya. This is Vandana Shiva, Dr. Shiva, like Dr. Suman Sahai, she's a physicist. Suman Sahai was a biologist, actually biotechnologist, so very, and by the way, Suman Sahai just got the highest civil award from the President of India just recently on her work on much of this, but hasn't necessarily translated into policy impact, right? It's known as Navdanya as well. It's in New Delhi. It does seed keeping and organic farming in 16 states. It has created seed banks. It has actually done sort of work with farmers, over 500,000 farmers, very interactive workshops. It's very women-centered. They claim they are women-centered. They have a Beej Vidyapeeth, which is School of Seeds, and this is something that I've been wanting to take many of our students to, which is actually held in Dehradun. Do a lot of development kind of discourse analysis and other work. And it's in Uttarakhand in the, okay, so let's see, okay. In 1999, Navdanya filed a writ petition in the Supreme Court against the Union of India and others, They've sort of pulled everyone in, the Department of Biotechnology, Ministry of Science and Technology, the Ministry of Environment and Forest, Ministry of Agriculture, Mako, Monsanto, everyone, okay, was on this. Writ petition alleged that prior to permission granted for trials and subsequent release of Bt cotton, and before there were any assessments of hazards, that the Bt cotton was already released into the market.